Hey everyone, I'm Luka and I will be presenting today on behalf of the Griffith University Lawyers Against Medical Negligence Society. Today I'll be talking about medical negligence and more specifically negligence when a doctor fails to warn patients about a risk and they suffer harm. So the failure to disclose risk. Today I'll be discussing 5 major points. Firstly, what is the failure to disclose risk and how is this an example of medical negligence? Secondly, why is this an issue and how prevalent of a problem is this in Australia and Queensland? Thirdly, what is our current state of liability like for failure to disclose risk and what are the elements of a medical negligence claim? Fourth, suggested reform of the current system, and then just an overall conclusion to sum up my points. So the interest group of this presentation is you guys, the QCPR. Honestly, generally, it's anyone who's been affected by medical negligence, friends and family who have other family members who have been affected by medical negligence, lawyers who are interested in medical negligence and failure to disclose risk, just anyone generally interested in recovery for the patients affected. So what is failure to disclose risk? The main problem we're looking at is that when a medical professional fails to disclose all risks of treatment, the cause of the accident is a breach by a medical professional to uphold their duty of care to the patient. The failure to state all risks surrounding a medical procedure affects the patient's ability to give informed consent. Informed consent is defined by the Australian Commission on Safety and Quality in Healthcare as a person's decision given voluntarily to agree to a healthcare treatment, procedure, or other intervention that is made following the provision of accurate and relevant information about the healthcare intervention and alternative options available, and with adequate knowledge and understanding of the benefits and material risk of the proposed intervention relevant to the person who would be having the treatment, procedure, or other intervention. If a patient is not told of potential risks of medical treatment, and as a result of receiving the procedure they get the risk, it is a negligent action on the fault of the doctor for not informing them of the risk. Informed consent becomes an issue as if the person has not been told, this may have influenced them to not give consent for the procedure. In a study conducted in 2012 of over 10,000 malpractice claims between 2002 and 2008 in Australia, 481 were disputes involving informed consent. Of these disputes, 106 were allegations about lack of explanation of risk, and 375 were disputes about allegations of undisclosed risk. From these 375 cases, 330 of them were cases where either doctor stated the risk should have been discussed but was not, doctor claimed risk was responsibility of another doctor and patient argue about what was disclosed, a bit sort of a he said, she said sort of situation. Doctor said risk was not disclosed, but treatment was not the cause of adverse outcome. In another study using the same data, 71% of cases where the main allegation was that the risks of treatment had not been mentioned or fully understood, and that the risk of benefit to ratio procedures had not been properly explained. In total, between the dates, around 1 in 30 were medical negligence claims, and around 1 in 9 were complaints of allegations with problems around informed consent. The cases took on average 1.8 years from filing to receive closure, with plaintiffs only receiving payment in 51% of claims. 11 claims went to court, with only 3 being successful. And the images shown here on the screen, that is a screenshot taken from the study and shows a graph. And as you can see at the very top, complication not mentioned is the obviously deciding leader, and you can see it's well over 300 cases. And on the right is a excerpt from an article by ABC, which just shows that medical negligence claims have cost Queensland is $390 million in 5 years. So, what is the current state of liability in Queensland? So, the current state of liability for a case of medical negligence is broken down into 4 main parts. Firstly, was a duty of care owed to the plaintiff by the defendant? Was this duty breached by the defendant? Was the defendant's action a direct cause of the breach? And finally, what damages are available as a result of the negligent conduct? So I'll be breaking each of these elements down individually and explaining how they are applied to medical negligence, and then give my critiques on how the current system operates and how I think it should develop into a better system overall. So, firstly, duty of care. The doctor and patient category is an already established category of duty of care. As stated in the case of Harrison and Stevens, when there is a direct physical injury, the plaintiff must show the injury was reasonably foreseeable. In the leading Australian case, Rogers and Whittaker, while discussing the duty that is placed on a medical practitioner, it was stated that the law imposes a duty to exercise reasonable care and skill in the provision of professional advice and treatment. The standard of reasonable care and skill required is that of the ordinary person exercising and professing to have that special skill. So the next category is breach. As the doctor and patient duty has been established, it also has to be looked at whether a doctor's failure to warn the respondent of the risk was a breach of their duty owed to their patient. As set out in Section 9 of the Civil Liability Act 2003, CLA, a person does not breach their duties to take precautions against the risk of harm unless the risk was foreseeable, the risk was not insignificant, and in circumstances, a reasonable person in the same position would have taken the precautions. In Section 21 of the CLA, it sets out the proactive and reactive duty of a doctor to warn of risk. It states that a doctor does not breach their duty of care owed to a patient or warn of risk unless the doctor fails to give or arrange the following information. Information that a reasonable person in the patient's position would, in the circumstances, require to enable the person to make a reasonably informed decision about whether to undergo the treatment or follow the advice. And B, information that the doctor knows or ought reasonably to know that the patient wants to be given before making the decision about whether to undergo the treatment or follow their advice. So understanding this is super important as it sets out how breach is established. So as mentioned, in Rogers and Whittaker's, which is the key leading case, the appellant, Rogers, is a surgeon, and the respondent was Marie Whittaker, which was his patient. During a surgery on Mrs. Whittaker's right eye, she became almost entirely blind. The appellant completed the surgery with the required skill and care needed, but there is an issue because he failed to warn her that as a result of the surgery, she had a chance of developing a condition in her left eye. Because she developed this condition in her left eye, it was particularly distressing as she had already been blind in her right eye since the age of 9. So whilst looking at the problem of breach, the key issue looked at was, did the appellant's failure to advise and warn the respondent of the risk inherent in the operation constitute a breach owed to his patient? So it was held in this case that the doctor breached his duty of care by failing to warn the plaintiff of the risks involved, and therefore his appeal in this case failed. Another key case is Chappell and Hart, 1998, which is pre the Civil Liability Act. So Mrs. Hart underwent surgery by Dr. Chappell, and Dr. Chappell did not warn her of possible consequences. These consequences set in, and she suffered damage and paralysis of her vocal nerve and lost her voice. Mrs. Hart commenced proceedings against Dr. Chappell. It was held that in the purposes of breach, the court said that the doctor should have known from her questions that she would attach significance to the risk, and thus it was material under the Rogers test to provide her with these risks before the surgery happened. So that's sort of going back to Section 21 of the Civil Liability Act, Section 21B, which states that information that the doctor knows or reasonably know to give the patient. So the doctor could have inferred to reasonably give her that information as she was, requesting it and asked a lot beforehand. So moving on to causation, this is one of the most difficult categories to establish in medical negligence. In establishing causation, it is important to consider what a patient would have done had they been warned of the risk by the medical professional. The general principles of causation are set out in Section 11 of the CLA, but we also look towards common law to help understand how the principles work within medical negligence cases. Section 11 of the CLA states, a decision that a breach of duty caused particular harm comprises the following elements. The breach of duty was a necessary condition of the occurrence of the harm, which is factual causation, and it is appropriate for the scope of liability of the person in breach to extend to the harm so caused, which is the scope of liability. It's also important to mention Section 11, subsection 3. If it is relevant to deciding factual causation, to decide what the person who suffered harm would have done if the person who was in breach of the duty had not been in breach. A, the matter is to be decided subjectively in light of all relevant circumstances, and any statement made by the person after suffering the harm about what he or she would have done is inadmissible. And Section 11, subsection 4, for the purpose of deciding the scope of liability, the court is to consider, among other relevant things, whether or not and why responsibility for the harm should be imposed on the party who is in breach of the duty. And Section 12 of the CLA also states the plaintiff has the onus of proof on proving on the balance of probabilities any relevant fact to the issue of causation. Looking at the case Chappell and Hart again, Dr. Chappell was stated that there was no causal connection between his failure to give warning and the damage suffered. The surgery provided by Dr. Chappell was done with care and skill, but as he stated, it was a random infection that could have been set in at any time by anybody completing the surgery. It was not disputed in court that Dr. Chappell was under a duty to inform heart of the procedure, but the onus of proof was on her to prove how she would have handled it differently, and she wasn't able to establish this, so the appeal was allowed. In another case, Rosenberg and Percival, the key theory of causation is whether the patient would have taken action to avoid the surgery by refusing the risks beforehand. If they had not refusing the surgery if they had known the risks beforehand. Human nature, but as also stated in this case, human nature being what it is, most plaintiffs will generally believe that they would have taken the option of avoiding risks had this option been granted, but we're not sure if this really would have happened. In the case Wallace and Camp, which is 2013, which is post the Civil Liability Act, Mr. Wallace was the plaintiff, and he visited Dr. Cam, who to have neurosurgery on his spine. So this surgery did have risks. One of them called neuropraxia from laying down too long, and another was a 1 in 20 chance of permanent paralysis. The surgery was unsuccessful, and Mr. Wallace sustained neuropraxia. He claimed damages from Dr. Cam for neuropraxia, as he claimed he was negligent in not telling him the risk to warn him of the risk of neuropraxia and paralysis, and he would not have done the surgery had he been warned beforehand. So this was held that the claim was dismissed at trial, as Harrison J. found that although Dr. Cam did negligently fail to warn or the risk of neuropraxia, Mr. Wallace would have still chosen to do surgery even if warned of neuropraxia. He then argued that the negligent failure to warn was not a necessary condition of the occurrence of neuropraxia. Moving on, we can look at damages and some of the... So damages compensation is only available for associated with the injuries from treatment and does not account for why the treatment was sought for in the first place. So you can't claim damages for what you were going to see them for. So you can't claim it for an injury that was before the treatment. An adult claimant has 3 years from the date of treatment to commence proceedings, but notice should be given within 9 months. A compensation order from the court may be ongoing payments, a one-off payment for loss of quality of life, or payments for future and past earnings. So what are the critiques of this current system? The current system of medical negligence focuses on a fault-based system of compensation and requires the plaintiff to prove on the balance of probabilities that the actions of the doctor breached the duty of care owed to them, and that was what caused the injury. Section 11, subsection 3 of the Civil Liability Act is especially an area for discussion as it attempts to deal with a hard question. In the majority of time, no matter where a patient chooses to get their procedure done, if completed with the required skill and care from the doctor, the risk would be the same. However, being able to say, if I'd been told about blank, I would have done blank, is completely up to them. In order to establish causation to be paid out, they're obviously going to say that they would have not gone through with the procedure. The exclusion of this makes causation hard to establish for the plaintiff and protects doctors. Another critique is that it takes a really long time for court proceedings to be heard, sometimes even as long as 8 years. It also can be very expensive to attend court, from the suits to the legal fees to getting to and from the courthouse. With all the costs added up, it's most often more than people can afford. So what's the suggested reform for this one? To change the law, we're recommending that we shift to a no-fault scheme of compensation for medical negligence. A no-fault scheme is a scheme that focuses on a quick compensation, rehabilitation, rather than place the fault onto a negligent person. These schemes are a product of legislation and help save cost and time by avoiding the legal battle of current proceedings. Claimants need to prove a causal link between activity and the injury to be covered and receive the benefits of the scheme. Looking at how a no-fault scheme is played out in nations similar to us, New Zealand has adopted a no-fault scheme called the Accident Compensation Corporation, or the ACC. In 2017, a British journal looked into how the ACC and how it has worked in New Zealand and provided several insightful comments about this system. The ACC aids with cost of treatment and rehabilitation for all personal injuries regardless of fault and bans the suing for compensatory damages. In New Zealand, there is not a culture of suing doctors like there is in places like Australia and the US, but there are still ways that doctors can be held accountable, such as medical counsel of competence and fitness to practice. Under this no-fault reform, the accountability of doctors was separated from compensation, and doctors have even adapted by helping their patients lodge claims with the ACC. As stated clearly, the goal of the ACC was to promote and protect rights, not just to punish. The article concluded by stating the ACC provides a more equitable access to compensation, more effective than the alternate fault system. The only critique held was that doctors are not really held to the same level of accountability. To conclude, I would like to just thank everyone for listening today, and I hope you have taken what I said into consideration. I think the failure to disclose risk is a very important area of medical negligence, and the shift to a no-fault system is something that is beneficial not to just patients, but also medical professionals. Shifting the burden from blame to rehabilitation is important. Awesome. Thank you.